Morning. The Board of Canvassers meeting is called to order at 10:04. Good to see you, everybody here. Looks like some familiar faces. Couple of comments before we start. Like last meeting, we are going to put the public comment will be at the end of the meeting. The plan is to go through and to take care of the items of business that are on the agenda. And with that, I would ask for a consideration of the minutes of the July 24th, 2026 meeting.
Move to approve. Second.
And moved and approved. All in favor?
Aye.
Aye. Second item on the agenda is the consideration of the sufficiency of the recall petition submitted by Ashley Arita against Victoria Bishop. The reasons for the recall printed on the petition. Between July 24th, 2025 and June 3rd, 2026, Antrim County Clerk Victoria Bishop made changes to voter records outside her statutory authority. Director Brader, do you have anything to say before we?
Just that obviously the subject matter of this relates to elections, but in general, the Bureau of Elections does not make recommendations to the board as to whether or not a petition is sufficiently clear, factual, based on conduct in office. The only thing we do is provide the list of the last sets of language that the board approved or rejected. So beyond that, we don't make a recommendation.
Thank you. That I would ask Ashley Arita. Ma'am, would you should we?
Good morning.
This morning? Hang on just a second.
Sure.
Should we swear in this one? Ma'am, we're going to swear you in before we go forward.
Sure.
You'd raise your right hand, please. You swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Would you state your name and spell it for the reporter?
Sure. Ashley Arita, ASHLEYAREEDA.
Thank you, ma'am. You've got 5 minutes.
Good morning, members of the board. My name is Ashley Arita, and I am the sponsor of this recall petition. When I appeared before you last time, members of this board made it clear that our previous language had a problem. It described the action taken by the Bureau of Elections rather than directly stating Victoria Bishop's conduct. We listened to the board, we corrected it. The language before you now says, between July 24th, 2025 and June 3rd, 2026, Antrim County Clerk Victoria Bishop made changes to voter records outside her statutory authority. The legal question before this board is actually quite narrow, and I want to explain why our language meets that standard. The law asks whether the officer and the voters can identify the course of conduct that is the basis for the recall. They can. Who acted? Victoria Bishop. What did she do? She made changes to voter records. When did she do it? Between July 24th, 2025 and June 3rd, 2026. What is the factual allegation? That those changes were outside her statutory authority. That is the course of conduct. Clerk Bishop's attorney argues that we have to identify a particular voter record, a particular change, and a particular day. But that asks for something more than Michigan law requires. The Michigan Court of Appeals explained in Hooker versus Moore that recall petitions are reviewed under a very lenient standard. The court specifically said that a meticulous and detailed statement of the charges is not required. What matters is whether the official understands the course of conduct being challenged and can respond to it. And in Hooker, the court upheld language describing a course of conduct over the official's term without listing every individual project, decision, or date. That matters here. There is an important difference between identifying conduct and itemizing every instance of that conduct. Our petition identifies the conduct. It does not have to become a spreadsheet of individual voter records in order to be clear. and there can be no serious argument that Clerk Bishop does not understand what conduct this language refers to. The Bureau of Elections communicated directly with her regarding these changes to the voter record. The Bureau's June 12th action suspended her access to the qualified voter file and stated that her actions fell outside the scope of her statutory authority. And in fact, that exact phrase, outside her statutory authority, is not something we invented for this petition. It comes directly from the state's description of the conduct at issue. Clerk Bishop's attorney now argues that those words are simply a legal conclusion, but Hooker tells us what factual means for purposes of a recall petition. The reason must be written as a factual assertion about the official's conduct. That is exactly what this sentence does. It doesn't say we think Victoria Bishop exceeded her authority. And it doesn't say Victoria Bishop is a bad clerk. It doesn't express an opinion at all. It states an occurrence as fact. Victoria Bishop made changes to voter records outside her statutory authority. And this board is not being asked today to hold a trial about whether that assertion ultimately warrants removing her from office. Hooker is very clear about that too. The court held that determining the ultimate truth and sufficiency of a factual recall allegation belongs to the electorate. That distinction is extremely important. Approving this petition does not mean that this board is voting to recall Victoria Bishop. It doesn't mean that you're endorsing our side, our petition. It only means that this factual allegation is sufficiently clear to be placed before the people whose signatures and eventually whose votes will determine what happens next. If Antrim County voters read this statement and disagree, they don't have to sign this petition. If we cannot collect the required number of signatures, there will be no recall election. And if we do collect enough signatures, Victoria Bishop will have every opportunity to defend herself, her conduct directly to the voters. That is exactly how the recall process is supposed to work. Clerk Bishop's attorney says this petition identifies no conduct. Well, respectfully, the words on the page say otherwise. Making changes to voter records is conduct. The dates identify the period in which that conduct occurred. Outside her statutory authority identifies the factual allegation regarding that conduct. And the Bureau of Elections' own communications with Clerk Bishop make unmistakably clear what course of conduct is being referenced. Michigan law requires identification. It does not require us to itemize every voter record. I respectfully ask you to apply the standard established by Michigan law, approve our petition language for circulation, and allow the people of Antrim County to decide for themselves what happens next. Thanks.
Thank you. Questions by the board? Thank you.
Thank you.
Mr. Kievsky. Morning, sir. If you would again do your name and spell it for the clerk.
Absolutely. And good morning, Mr. Chair, Madam Vice Chair, and member of the board. I know we have one absent right now. Kevin Kievsky, Kijewski. I'm an attorney representing Victoria Bishop, bar number P74-153. You have our submission, so I'm just going to be very brief because you have a whole bunch of other stuff on your agenda. So 3 weeks ago, the problem with the petition was that the only actor within it was the Bureau. The sponsor listened and fixed that. I acknowledge that. That particular defect is cured. However, the statute's requirement is not. The new reason names the officer, granted, of course, but it doesn't identify anything that she did. Not one change, not one record, not one date. A 10-month window is not a date. And specifically, I think it comes out to about 315 days. So let me be candid with you what we're not asking for. We're not asking you to judge whether the accusation is true. That belongs to the voters. We're not asking for detail. 9 words were enough in the Whitmer cases. And we're not asking for a pattern because, again, a single act would suffice. Every one of those rules is about how thinly an act may be described. Leniency can forgive a thin description of an act. However, leniency, and more so the law, cannot supply an act the petition never identifies. So what does identification look like? The board showed us in June. You, ladies and gentlemen, showed that to us in the county prosecutor recall. So I took a look at exactly that hearing in addition to the results of that. And every approved reason named a case, a date, and the particular act. A plea was entered in a named case, and all this stuff happened on June 13th of 2025. So it's officer, act, date. In this particular instance, we don't see that to be the case because you can't just say from date A to date B, stuff happened and it fell out of someone's statutory or legal authority. That is calling for a legal conclusion. That is giving a particular opinion. That does not state exactly what the heck is going on or what is being alleged. And one other quick thing I just want to note for the board and also for any others that may be listening, this is not about whether Victoria Bishop, my client, can identify the course of conduct. It's about the voter. And the voter is saying or seeing 315-day time span. I don't know exactly what happened. I'm just being told that someone did something outside of their authority. That's really a non-starter. I mean, again, let me kind of give you another hypothetical. Let's talk about Governor Whitmer. And Governor Whitmer, and you had some Republican or conservative-oriented person with a grudge, they come up here and they say that, you know, from date A to date B, Governor Whitmer signed executive orders and they fell outside of her statutory authority. That would not be approved. I wouldn't condone it. If I had a client that came to me, asked me to defend it, I would not. Because I would tell that particular individual, you have to give a particular executive order. And in the Whitmer cases, they gave the actual number. Here, in this particular case, you don't have to give all the different types of things. I'm not asking for a spreadsheet. Neither is Victoria Bishop. But give something that's factual, that could be discernible, that is actually something that can be identified. You do that, you meet the statutory requirements, then I suppose it's a ball game. But today, we don't have really the players on the field. We just have certain positions sort of mixed up a little bit differently in this particular petition. And I have no ill will toward the person organizing the petition. What I do want to do is, I don't care if I represent a Republican or a Democrat, and I've represented both folks on both sides, but we have to follow the law. So with that being said, what I'm asking this particular board to do is to reject the petition language. Why? Because again, it doesn't have the particularity and the specificity, not even the bare bones that is required. And again, I know that you have our submission. I was able to take a look at various things that you, ladies and gentlemen, said in front of myself, in addition to the petition organizer last time. And I think it was Member Cummings that said, and I'm paraphrasing, but it's almost a direct quote, you have to talk about this and that, what they did. In this particular instance, there is no this or that. It's 315 days that someone did something that typically they would do. They work with voter records, but then you say, in terms of a legal conclusion, that it fell outside of her statutory authority. This does not pass Michigan law, nor any of the applicable rules that have come forward from the Michigan Court of Appeals. So we ask you politely to please reject the petition today. Thank you.
Thank you, sir. You nailed that right on the timer. Questions for Mr. Kiewski?
Well, I feel like I have to respond to you since you brought up my quote, which I appreciate.
Sure.
So the case that we discussed in June regarding the other, I believe it was the same position, correct? I think it was the clerk. Or no, it was a prosecutor.
It was the county prosecutor, I believe, on
county
the west side of the
prosecutor.
state.
Yeah, so that case is very different than the case at hand today. That was in regard to two specific cases. So I don't see the comparison, and I'll do respect to you. I appreciate it, but I don't see, this is very different. This is going in over the course of a year, almost a year, going in and changing multiple voter records. So I see this as very different. And as far as my quote saying, you know, we need to show this and that, or what, I don't recall what I said, but I do feel that the change here that was made regarding the dates, it does give a time period. Yes, it is a long time. That could go towards the egregiousness of the actor in this case, not being too vague. To me, it looks like there's been a lot of changes. That would be me as, if I looked at it as a voter. And then it does give the specific actions, which was change voter files. So I disagree with your position here today, but thank you.
May I briefly respond? I know this is not a
Please go
court
ahead.
hearing. And, again, just trying to paraphrase what I believe that I think you said, this and that. To take a look at that county prosecutor recall language that came forward. Of course, every particular case that comes before this board, it's going to be a little bit different. But still, the statutory, in addition to the law, applies the framework from the Michigan Court of Appeals. There has to be enough specificity in identified act. So for example, I'm not here to try to help, the petitioner in this particular case, but you can certainly give in a hypothetical time frame. But you have to say one thing that happened during that particular time frame. Here,
Did. And I'm sorry, you said you were going to respond to me and you have not looked at me this whole time. So
well,
I
I'm
want to
looking
say
back
to you,
I
no, I
apologize.
want to say to you that she did. She said change voter files. The average voter does not need to know what that means. They might not even know what is capable to change. So I disagree with you, and I don't want to go back and forth with you on my opinion. I respect what you're saying. I've heard you, and I'm saying I disagree with you.
Thank you, madam.
Thank you.
Yep.
Mr. Chair,
I have nothing.
I don't think I have any questions for you either. I've read everything in the package.
All right, thank you very much.
Thank you, sir. Any discussion among the board?
So,
Okay. How about if we do the vote and then we can explain it? Does that work?
I'm sorry, wait.
If we take a motion, do we need a
Well-
motion to go forward, or do you want to?
No, our motion does need to say what the reasons for our decision are.
right.
I think we do, but do we take the vote
Right,
first? or-
well, I think that we could,
You can't-
okay, I would move to find that the reasons are clear because the recall petition identifies the course of conduct, changing voter records over a period of time outside of the clerk's authority. I think that both the voters and the clerk understand precisely what the conduct is, so that they can make a decision whether or not to sign the petition, and the clerk can respond as she wishes. So I think that it is factual and clear.
Are you making that as a motion?
Well, I'm saying that
Continue.
I'm saying that I think it's factual and clear. And if there's no further discussion, then I will make a motion.
I have an issue with it. So the factual and clear, when I read the note that was sent to Victoria Bishop from Director Brader, it was extremely clear as to exactly what the problem was. It was extremely clear as to Victoria Bishop sending cancellation notices. And it was extremely clear as to Victoria Bishop using formats and using processes that were completely outside cancellation notices and request change notices being sent at once. Notices that were being sent that were not, that did not contain all of the warnings, did not contain all of the disclaimers. So I thought that there was extremely clear information. And to me, this petition, if it was going to be brought forward, Noenberg has been mentioned. We had Noenberg come back with an enormous amount of detail that didn't exist in the first one. There have been items here brought up with regard to Whitmer, with Governor Whitmer. Again, detail being requested. And I think that there was plenty of detail that could have been put in here that would have alerted a voter to say, oh yeah, okay, she's canceling voter records. That's an issue. Or she's canceling voter records. Maybe it's not an issue. I can't imagine that. So I guess I have a problem with the full factual side of this. I would have preferred to have seen something in there that doesn't need voter names. And it doesn't even need voter dates, but it certainly needs that there was very clear direction that was set out by the letter. And so I guess I still have a problem with this petition. So.
I would agree with the recall petitioner that they don't need to set forth because it is a course of conduct. It's not simply individual actions, which are the subject of the complaint, but a course of conduct over a period of many months where the clerk is acting outside of her statutory authority. So I think that is sufficient, both for the clerk who is being essentially charged here by the recall petitioner with acting outside of her authority, making changes to voter records. I know that Ms. Arita argued to us, and I think very eloquently, that the kind of detail which I think you're suggesting, that kind of detail is unnecessary and that the Court of Appeals has said that kind of detail is unnecessary. So where the clerk has acted over a significant period of time, according to this, making changes in voting records outside of her authority, I think that is more than factual and clear. I don't think the voters need more detail. I don't think the clerk needs more detail.
I agree. I mean, I think I made my position pretty clear, but I don't think a voter needs to know more than there were changes to voter records. It could be more than what would be listed. It could be less, and keeping it open, I think, is more fair to Victoria Bishop.
I've told you where I stand, so
I'll make a motion.
I'd make the motion.
I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Ashley Arita against Antrim County Clerk Victoria Bishop on July 31st, 2026 are factual and sufficiently clear because they set forth a course of conduct occurring between July 24th, 2025 and June 3rd, 2026, making changes to voter records outside of her authority. I think that is clear for both the voters whose petition signatures are sought and the clerk who will defend herself against these.
Second.
And moved and seconded. All in favor?
Aye.
Opposed? I'm an A. Moving on.
Just to clarify, just for the record, that means it does not pass because it needed three votes.
Does not pass.
Yeah, so it needed 3 votes to pass. What's that? Oh, yeah, sorry. Well. Okay, so sorry, Heather's correcting me. Because there's 3 of you here, it could have passed with 2, but it would need 1 from each party. And so because both of the yeses were from the Democratic side, it does not pass.
Okay. And do we need to state anything in addition for the petition?
So, I mean, the reason that we put the because in the motion is there's a court decision that when the board rejects recall language, that the sponsor of the language needs to be given an explanation as to why it was rejected. I think that you've done that, Chair Housecamp. So in my opinion, there's sufficient information for the sponsor.
Okay, so we're set. Thank you. Moving on, item number 3 is a report on review of qualifying petitions filed with the Secretary of State for the November 3rd, 2026 general election. Director Brader.
Thank you, Chair Housecamp. So these are candidates that are running without party affiliation. So their deadline is, and the board's determination is later because they're going straight to the November ballot. We have 4 candidates here that we reviewed filings for. One of them, and I apologize for any mispronunciations here, but one of them, Sarah Kimbensi will be discussing on the next agenda item because there was a challenge received. So she's not part of this motion. But the other 3, we are recommending that the board put on the ballot because we have determined they have sufficient petitions and there's been no challenge.
Thank you, sir. Questions for Director Brader?
I do not.
And we need no motion or action on this, is that correct?
We do need a motion to,
Do need a motion.
yeah,
Thanks
it
for
should
log
be in your
down.
packet.
Well, give me a second to
Yep.
log back in here, just a minute, Wayne. My machine went down on me here,
Fine, okay, I got it back.
flying in the blind there for a second. Back. Go ahead, motion.
Okay. I move that we accept staff recommendation and find the petitions filed with the Secretary of State by the candidates appearing on the attached list sufficient, with the understanding that the list does not contain the name of the specified candidate who has petition sufficiency issues pending before the board. I further move that the candidates who filed a sufficient petition with the Secretary of State as a candidate without party affiliation for the offices of U.S. Representative, State Senator, State Representative, be certified to the Secretary of State for the November 3rd, 2026 general election ballot. This certification is to include any additional candidates we find to have filed sufficient petitions under today's hearing.
Moved.
Second.
And moved and seconded. All in favor?
Aye.
There's no one opposed. Moving on, item number 4. Consideration of the sufficiency of the qualifying petitions submitted by Sarah Kimbensi for the office of State Senator, 38th District. Ask Mr. Brewer. Before we do, could you do me a favor and just let me give Director Brader an opportunity to intro this? Is that fair?
Sure, I'll try to be quick, Chair Housekamp. So this is a no party affiliation candidate for State Senate 38th District, Sarah Kimbensi. She has to submit 1,500 valid signatures. The total filing received was a total of 2,339 signatures. After face review, staff determined that she was left with 2,142 valid signatures, so still more than 600 over the number needed. We did receive a challenge to the petition, which we'll hear about momentarily, on various reasons. But the primary issue that we were looking at here was circulator issues. So there's one circulator that was challenged on the basis that his signatures within the petition did not match. And there's also an argument that because the candidate has no party affiliation and that this circulator is associated with the Democratic Party, that the circulator shouldn't be allowed to submit petitions essentially for this candidate. We did not identify any legal requirement that the no party affiliation candidate couldn't have a party affiliated circulator assisting them. So we didn't reject any petitions on that challenge basis. We also did get some additional information from the circulator about his signatures varying, and we also determined that although there is some variance in the signatures, they did all agree sufficiently with the qualified voter file signature. So we didn't reject any on that basis. There were also challenges to some petitions that were circulated by the candidate herself, and specifically some petitions that there was information submitted arguing that the circulator did not, in fact, witness those petition sheets being signed when she signed the petition sheets. There were 2 specific sheets that were called into question. We did not, even if those were thrown out, the 19 signatures on those 2 sheets, it wouldn't change the overall recommendation, which is that she would still have a sufficient number of valid signatures. And then the remaining number of valid signatures, the remaining number of signatures in question would still not be enough to take her under the 1,500. So we didn't grapple with those additional 268 signatures that were challenged. There's also an argument, which I think we'll hear about, that the board should consider disqualifying the candidate based on the fact that there were circulators that signed, including allegedly the candidate herself, sheets that that the circulators did not actually witness. We are not making a recommendation to the board on that, and I think we'll hear about that as well. I would refer you to the Attorney General for advice on to what extent the board can consider that remedy here. But we're not considering the notion at the staff level of throwing out all of the candidates' circulator signatures because of this issue. We only identified the ones that were in question, the 2 sheets that were in question. And again, those would not be enough to throw the petition out. So based on that, we recommend that the board determine that the petition is sufficient.
Thank you, Director Brader. Mr. Brewer. You know the drill.
Members of the board, I am Mark Brewer, partner at the law firm of Goodman Acker, and I'm here on behalf of the challenger Linda Dunkers. Over the past few years, this board has lamented the fact that it's been unable to hold candidates and committees, sponsors of petitions, directly responsible for the illegal conduct of their circulators. It has disqualified signatures. It's referred circulators for prosecution, but has not yet held those ultimately responsible for illegal conduct, the candidates and the proposal sponsors, accountable for that conduct. This is the board's opportunity to hold a candidate who has admitted to falsifying the certificate of circulation accountable by disqualifying her from the ballot. It's an important opportunity to send a message that a candidate or a ballot question sponsor is ultimately accountable and will be held responsible for misconduct during the course of their petition drives. As the staff report points out, the board has the legal authority to disqualify a candidate even if they have enough signatures to otherwise qualify under MCL 168.544C11, which says that after a canvass and a hearing, if the board determines that a candidate knowingly or aided and abetted the falsification of signatures in a circulator certificate, they can disqualify the candidate, again, regardless of how many signatures they may have collected. Sarah Cambensi meets those legal standards and should be disqualified. Let me briefly review the evidence that we had submitted. In the very limited time available, we submitted 6 affidavits of petition signers who swore that the circulator who signed was not the person who presented them with the petition. Marie Moisio signed petition number 63, which Cambensi claimed she was a circulator of. Moisio, in her affidavit, stated that Cambensi did not collect that petition, that she did not present that petition to her for her signature. Mary Lou Blomquist signed petition number 188, which Cambensi also signed as circulator. Blomquist, in her sworn affidavit, says Cambensi did not collect my signature. John Bramsey signed petition number 154, which Cambensi also signed as circulator. Bramsey says in his affidavit, Cambensi did not collect my signature. Robert Butchko signed petition number 154, which Cambensi also signed as circulator. Butchko, in his sworn affidavit, says Cambensi did not collect my signature. Miaja Fox signed petition number 86, which Cambensi also signed as circulator. Miaja Fox, in her sworn affidavit, Cambensi did not collect my signature. We also submitted as supplemental evidence last week a Facebook post by a supporter of Cambensi named John Plaxco, in which he testified I collected signatures for Cambensi, but you can search the signatures and the sheets in vain for the name of John Pletchko as a circulator. So plainly, somebody else signed the sheets that he circulated on behalf of Cambensi. Finally, David Blomquist signed petition number 120, which has Barbara Cambensi as circulator. Blomquist in his affidavit says Barbara Cambensi did not obtain my signature. Where there's smoke, there's fire. We had only a few days to try to track down this evidence, but we came up with significant evidence that in fact circulators who signed these petitions were not the ones who circulated them. So what is Sarah Cambensi's response? She has no response to 4 of the affidavits or to our claim as to Mr. Plexco. Moisio, Mary Lou Blomquist, Fox, and David Blomquist, she has no response. She doesn't deny that she falsely signed the certificate of circulation as to those. Now, she does claim that as to Butchko and Bramsey, those are somehow signed in her, quote, presence. Because, quote, and I quote her response, her friend asked if they would be interested in signing. Well, the friend is the circulator, not Miss Cambensi. Cambensi says, well, I was 10 to 12 feet away and I saw what was going on. We don't have circulation by proxy in this state. The circulator of that petition was the friend of Cambensi who handed it to those 2 voters. It was not Sarah Cambensi. So there's ample evidence here that at least in these 6 affidavits plus the evidence from Mr. Plaxco, that Cambensi did not actually circulate these petitions. And I suspect, given the pattern here, that there were significantly more. But regardless of how many there are, and regardless of how many signatures she collected, this is again the board's opportunity to say to a candidate, the law is clear. We will not tolerate falsification of circulator names, and you should be disqualified from being a candidate. And that's exactly what we're asking the board to do today. Just as signature forgery is unacceptable, so too is a candidate intentionally and knowingly falsifying her name on a petition as the circulator, and also knowingly having other people falsify their names on petitions they did not circulate. So we ask the board to disqualify Ms. Cambensi from the ballot. Thank you.
Thank you, Mr. Brewer. Questions from the board?
Yeah, do you mind, when you, in the beginning said that, the candidate admitted to falsifying the document, can you explain again what did she admit to falsifying?
Well, first of all, she didn't deny in her response,
Okay.
but she did say that my friend presented the
Okay.
petitions to these 2 circulators who submitted affidavits. That to me is an admission that she didn't circulate it. You know, she says I was 10 to 12 feet away. I mean, under that analysis, I could stand at the back of this room and witness Mr. Hauskamp hand Ms. Gerwitz a petition and say I was present and I could sign that petition as circulator. That's absurd. That is not what presence means. It means the person who handed you that petition and asked you to sign. And Ms. Cambensi did not ask those 2 people to sign. Her friend did, and her friend should have signed as circulator.
Okay. So she didn't admit that she falsified a document per se.
She didn't,
She didn't deny.
no, she didn't use the legal phrase.
Right.
No, she did not. But as to the
Yeah,
4, she
yeah.
didn't deny. And as to those 2, she admitted conduct, which is falsification.
Yeah. Okay. Thank you.
So, Mr. Brewer, you are asking us to not simply disqualify. I thought that part of your request was to disqualify all of her petition signatures because of the affidavit evidence that she had not circulated ones where she said she had. And I thought you were asking us to, because of that, to disqualify all of her petition signatures. But as I understand it now, you're asking us to not just to draw the inference that other petitions were falsely certified, but to say that she falsely circulated these, or falsely signed the circulator certificate, and therefore she should be disqualified under the standard which you cited.
Under subsection 11, yes, either approach works.
Right, I
I
thought,
mean, if you want to conduct an
Right.
investigation, put her under oath and go through sheet by sheet and have her swear, and whether she's circulated or not, that's fine. But I think the easier and the obvious step here is to use subsection 11. She's guilty. She knowingly falsified her name on petitions. She allowed other people to do that. And the board has the authority to disqualify her on that basis alone without examining the petitions.
Mr. Brewer, you know how I love to ask you questions, but I just don't have any to ask you on this one. So I think we're all set.
Thank you, Mr.
Very
Chair.
much. Would ask Sarah Cambenzi, are you here? Good morning, ma'am.
Morning.
You are not an attorney, is that correct?
I'm not an
I'm going to
attorney.
ask you then if we could swear you in.
Sure,
If you would raise your right hand, please. You swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Now, I
Thank you.
also need for you to state your name and spell it for the clerk.
Sure. Sarah Cambenzi, SARA-CAMBENSY. All
Okay,
right.
ma'am.
Thank you. Good morning. Thank you, Mr. Chairman and members of the committee. My name is Sarah Cambenzi, and I'm a candidate running as a nonpartisan for Michigan's 38th Senate District. I'm here to provide comment on my challenge filed by Mr. Brewer on behalf of Linda Donkers. There's a long history dating back to 2017 when I ran as a Democrat for the 109th District that my campaign believes there is a direct correlation to the challenge before you today. As the candidate that was never supposed to win, to a lawsuit filed against me that I won by a former campaign manager, to being slammed for being too moderate while I was in the legislature, to being told that I don't have a right to donate to my campaign money that I raised to the candidate of my choice in the 2022 primary race to replace me. This small group of Marquette County Democrats have been nothing but nasty towards me. Former Chairman Dillon even asked if I wanted to fire Mr. Antela, who pulled the petitions towards the end of my 2017 campaign. I told him I did not. I would just appreciate if he did not work on my campaign anymore. Before I ran, I gave the courtesy that I was running as an independent to Mr. Curtis Hertel, who is the chair of the Michigan Democratic Party. And I said that my intention was to run as an independent. He tried to convince me and the operating engineers, who I am a contractual employee to right now, to not run as an independent. He was worried about former Mayor Duggan and the impact that independents are going to have on Dem races statewide. He also agreed that I could win as an independent, so it became the question of what's the problem. So was I surprised that this challenge by Mr. Brewer was filed against me? We knew they were going to try and find something. And I would like to publicly state that I disagree with all three affidavits that were in the challenge. We had some time to actually look at the third affidavit from the woman that signed, and can piece that back to July 3rd, Lower Harbor Park, with my friend Jim, who was talking and actually introduced me to her. I had a long conversation with her about her father and the type of relationship she had. I even gave her a hug after that. So I've been getting personal emails from the other two gentlemen who signed the affidavits. Those have been forwarded to the Board of Canvassers as well. Basically, they're saying that after a few drinks, one of them was asked to sign the affidavit. So these members of the Marquette County Dems started with the end goal. How do we get Sarah off the ballot? How do we keep Sarah off the ballot? And they worked their way back from there. The three affidavits, the only part of the challenge that has any option left for Mr. Brewer and these Marquette Dems that are teaming together behind the scenes, prove how the challengers were willing to take advantage of three very nice people and make them sign these. And I think should there be an opportunity to have them make a comment, I think you would find the complete opposite of what Mr. Brewer said. John Plaxico, I did not give him petitions to circulate for me. So if he circulated any petitions, they would have been given from someone else. And I do not know if he did that, and I do not know if he signed the bottom. The other 4 additional affidavits were circulated by my mom. And I know all 4 of those people. I babysat for 2 of them. And the other 2, they've been longtime family friends of my family. Played basketball under my great uncle and have been good family friends. That is a mistake. My mom signed several other sheets for me. When I collected all the sheets, I didn't look closely and I signed what was sitting in the front seat of my car. So when Mr. Brewer talks about admitting that, yes, that is one sheet with those additional 4 that I should not have signed. The other thing I'd like to note is that members of the Marquette County Democratic Party have been working tirelessly making phone calls to people who signed, asking them if I was actually the one who verbally asked them, if I was the one who physically handed them the clipboard, and if they felt coerced into signing. The people who were taken advantage of, or were a very small group of people who have a vendetta for me personally, the people who have taken advantage of me. And I think it's abhorrent that they are so egregiously brought in these other people to be the face of their challenge who had no idea of the long backstory between myself, who do not know the rules of circulating a petition or signing it. And I guess I would like to be put on the ballot. My campaign has always said, any signatures that do not qualify need to be taken out. Any mistakes need to be taken out. But there is no reason why I would purposely do anything illegally to throw myself off the ballot and discount the over 2,000 people that wanted to say as voters to have a third choice. And with that, I guess, you know, I do have my campaign manager here. You know, 2 of the 3 claims in their challenge was against him, which again, he's going to be able to tell you that he also feels that he was pushed out of the party simply for supporting me. And so to say that all of his signature blocks were his forged signature, egregious. To say that he can't circulate petitions for me because he's a Democrat, egregious. And I would just hope that you look at all of this together when making a decision whether or not I should go forward and be put on the ballot. So thank you.
Thank you. If you would stay, questions for? Yeah, Benzie?
Well, quick questions for you.
Mhm.
The first one is, how many sheets did you say you should not have signed?
The one where all 4 were on it that Mr. Brewer brought up at the end. So there were the 3 in the original challenge. There was 1 sheet that my mom circulated
Okay.
with those additional 4.
And how many voters, how many signatures were on those total, do you know?
I don't know offhand.
Okay. And then you said you talked to a few of the people who signed an affidavit.
The 2 gentlemen have been emailing me saying that they wish that they didn't. Those emails have all been forwarded to the Bureau.
Okay.
The one gentleman who seems pretty nervous sent me one saying that after a few drinks, he was asked to sign the affidavit from someone in the party. He just sent me another one late last night saying that he's so sorry that he did this and he'd like a yard sign. And then again, the woman that we just couldn't, in the 3 days that we had, kind of figure out where I was and who she was and when she signed. I was able to trace that back to Mr. Call him Jim, my friend Jim, who I was with on the 3rd of July. And he introduced me to her at the fireworks and we had a nice conversation. And I'm not even sure that she's aware of the predicament this has put her in.
Okay, my last question is, you discussed, a couple items as being untimely that was filed by your challengers. What, can you? tell
That's
me-
those are the additional 4 affidavits that were
Okay.
not turned in on time.
Okay, thank you.
Yep.
Much of what you have argued is really not relevant to the question before us. Whatever kind of bad feelings or machinations within the party are not any reason for us to either, either reject or accept the challenge which is made. So the challenge is to the circulator signature on a number of petitions. And what I hear you saying is that you were close by on a couple of them. You're also saying that you signed one petition that you ought not to have signed as a circulator.
Yeah, the first 2 gentlemen, it was a case of getting caught talking to the previous person that signed. And then seeing 2 people and my friend saying, I'm going to go just ask them, literally about 12 feet away. Me seeing them, right? Noticing that I know those 2 people, they're there. She's going to go ask them. And I went over and thanked them and talked to them after. And we got the clipboard. The third one, Maya, I was the one who had the clipboard, handed it to her. Jim made the introduction.
I have not.
Do you have those emails that you referenced with you?
I have 2 of the other one, we didn't get a chance to print off, but I do have the 2 latest ones, yes.
You mind if I just look at them?
Thank you. Yeah, okay.
Thank you. I don't have any questions about what happened. I do have a question for you. You have your campaign manager, Jason Chapman, here with you as well.
Yes.
You said that he also has testimony.
I think he would just, I guess, like to reiterate that, he felt it was a way to bring him in and kind of get a little bit of revenge on him, as the party hasn't been kind to him either. But certainly, he did sign an affidavit saying that is my signature in the signature block. The crazy assertion that just because he's a Dem, he can't collect signatures. I mean, all of this has been extremely personally damaging, not just to me, but I think to him, to have this all out there and unfair.
The number of sheets that are involved where you were in a social setting and you were walking around and thanking people and signing, and the number of sheets is 3 or 4.
Well, it would be the 2 gentlemen on one, and then the third woman was on a different one, and then there was one that my mom had. So that would be the 4th one, or the 3rd one.
Thank you. We don't have any more for you.
Okay.
Thank you for your
you.
time.
I
You-
have
you do?
something.
Okay.
I understand that the challenge to signature, that there was a challenge to the validity of Mr. Chapman's signature.
Yes,
That was what you understood.
correct. And
And the Bureau said in its staff report that those signatures were compared to the qualified voter file and were
yes,
actually Mr. Chapman's signatures, I believe. Is that not correct?
That's correct.
yes.
So, right, but the Bureau has said that those were Mr. Chapman's
Yes.
signature. In addition, there was an assertion in the challenge that Mr. Chapman could not circulate for you because
He was a member of the Democratic Party.
and I don't believe that was that identified or addressed in the staff report?
Yes, it was addressed in the staff report, and we didn't see a basis to reject signatures on that for that reason.
I similarly do not see any reason to reject signatures on that basis. You can have whoever you want circulate your petitions. I guess those are the questions I have with regard to Mr. Chapman. But
Okay.
as Chairman House Campus said, you were circulating petitions in a social setting, or
Yes.
those were being circulated.
Yeah, and
in a
there was
social
the
setting.
assertion that there's no way that I could get that many signatures. One, I was a former legislator in the area, so people know me, they remember me. Two, once we got going and we had people in these communities and events, a Gus Macker alumni softball game, steelworkers
I
retiring
don't think
meeting.
there's a question about whether you could have gotten those numbers of signatures.
Yeah.
The question was about the circulator certificate on a number of petitions.
Correct.
And you have discussed that with us.
Yeah, yes.
Okay, thank you.
Thank you for your time
Thank
this
you.
morning. Before I call Mr. Chapman up, Director Brader, if the sheets that were in question here that were the sheets that we've talked about in question here, that makes no difference in the staff report outcome.
No, I mean, so there are some sheets that Mr. Brewer mentioned that were not reflected in our staff report because we didn't receive that information in time to consider it as a challenge for our staff report. The board can still consider that information because it was submitted to you at least 48 hours before this meeting. But based on what I've heard, I don't believe that those additional sheets would come close to taking the candidate below the threshold. I think the only circulator issue is if the board considered the other issue, the argument that all of the signatures should be thrown out on that basis.
All right, sir. Thank you. Thank you,
Thank
ma'am.
you.
I would ask Jason Chapman. Mr. Chapman, I'm going to ask you to raise your right hand.
Good morning.
You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Before you begin speaking, would you state your name and spell it for the clerk?
Jason Chapman, Jason, Chapman, Chapman.
All right, sir.
Okay. I'm first and foremost, I'm a campaign manager for Sarah Kim Benzie. My history goes back with her to 2017 when I was her campaign manager. Also a legislative aide for her in Lansing from 2017 through 2018. I managed her reelection campaigns and I'm her current campaign manager. I'm here because one, I was mentioned in two of the three accusations from the challenger and the attorney. One, I've been a nonpartisan elected official for 6 years, serving on the Ishpeming City Council, serving also as mayor of the city of Ishpeming from 2022 to 2024. During that time, I did step back and I have continued to step back from the Democratic Party because I believe as a nonpartisan elected official, I shouldn't be participating heavily in Democratic politics or Republican politics. I also have, yes, been pushed out of the party by people that have been working to, ensure Sarah Kim Benzie does not get off the ballot. So I think there's definitely a personal part to this. But the one thing I also want to point out is in the manual, it says that the circulator must be in the vicinity of the people who are doing the signings. Whether that is from one person handing the clipboard to the next person after they've signed it, or what, I think there hasn't been really a determination in that. But the manual does clearly state that the person who's gathering the signatures has to be in the vicinity. And I think we've proven that that is the case in that. But like I said, all of those signatures on those documents are mine. I personally signed those. I don't know why anyone would want to forge my signature on them, but I'm happy to answer any questions in regards to those. But yeah, I did sign all of those sheets, and that is my signature. And my signature can vary. I have some health problems. Once in a while, my hand shakes and stuff like that, so that can also determine why.
Thank you for speaking to us this morning. Are there questions for Mr. Chapman?
Did you read him the oath? Did he swear?
Did.
Okay, I missed that.
Mr. Chapman is under oath. Ask
Yep.
whatever you'd like.
Yeah,
Hmm.
please, go ahead.
Yes.
I have nothing.
Okay, thank you. I appreciate your time.
Thank you very much, sir. Is there any conversation, discussion we need to have? Vice Chair?
You know, I find it troubling, but I don't find that the conduct of the candidate here was so egregious that her petitions should be rejected. We do want people to be careful. We certainly have seen instances where circulators were engaged in criminal activity. But this, and where, and I'm sensitive to the argument that Mr. Brewer is making. I think it's a good one that we do, if we have the opportunity to to actually have a circulator who can be punished essentially, or, who can be punished pursuant to the statute. Where we have a candidate who can actually be held responsible for circulator misconduct, that we should act. But I don't find from the evidence before us that the conduct of the candidate here, as I said, was so egregious. I do understand that we should reject the petitions where we have evidence that those petitions were not signed by the person who actually signed a circulator.
I'm in agreement with you. I think in order to take that approach, we would have to leave common sense at the door on this one. If it's okay, I would like to make the motion this time. Does that work? Want me to wait?
Yes, no. Something happened.
I was gonna let you fix your phone there for a sec. I move that the board accept the staff recommendations and find the qualifying petition filed by Sarah Cambenzi sufficient.
Second.
And moved and seconded. All in favor? Aye. Thank you. Note it's only 10 after 11 and we are coming up here. Thank you, Mr. Brewer. Moving on, we have the consideration of the 100-word summary of purpose for the initiation of legislation sponsored by Michiganders for money out of politics. And Director Brader, I'd like it if you would read the language.
Sure, the proposed language is caption, a proposed initiated law to prohibit campaign contributions from certain regulated utilities and apply campaign finance laws and regulations to additional types of political communications. And the summary is, the proposal would prohibit regulated electric and gas utilities, contractors with over $250,000 annually in government contracts, and people and organizations with substantial connections to these utilities contractors from making direct or indirect campaign contributions to those who run for or hold offices that impact them. Expand laws regulating spending on political communications, including those requiring disclosing donor information, to apply to communications clearly identifying candidates for ballot questions, even if they do not expressly advocate voting for/against them. expressly apply the law requiring disclosure of who paid for political communications to internet political communications. Should this proposal be adopted? Yes, no.
Thank you, sir. We have three folks who would like to speak to this who are attorneys representing. And I would invite Ms. Flower, excuse me. Mr. Brady, do you, I'm taking these in the order they came in, so do you have an objection to that, or are you okay? Okay? Ms. Flower, it's always nice to see you. Is Mr. Gordon joining you? Mr.
He's
Gordon,
also-
it's always nice to see you as well. If each of you would state your name and spell it for the clerk.
Good morning, Mr. Chair and members of the board. Olivia Flower, OLIVIA-FLOWER of Dykema-Gossett, appearing on behalf of Protect My Free Speech. We will be significantly shorter today than we were last meeting, and we only have a single sheet of paper for you, so not reams and reams and reams. But on July 10th, we submitted a public comment letter on the proposed ballot language, which I again present to you today. I trust that you've been able to review our remarks, and I want to make two short points today regarding our requested revisions. And we'll, if we can just take a moment, we can
You may.
pass out that language.
Would you make sure Mr. Brady has one as well?
Thank you.
We appreciate the work that went into drafting the director's proposed language, and we just have two small revisions to propose. The first is to the caption to present to voters, to just provide a neutral introduction to the proposal. And number two is to reorder bullet points 1 and 2 to make it consistent with how the architecture of the proposal reads. We make no proposed changes to the actual text of the bullet points proposed by the director. So MCL 168-485 governs the wording of the question. It must apprise the voters of the subject matter of the proposal. Though it need not be legally precise, it must be clearly written using the words that have common everyday meaning to the general public, and it must not create prejudice for or against the proposal. The caption is the voter's introduction to the proposal, the first impression, and the director's caption reads, proposed initiated law to prohibit campaign contributions from certain regulated utilities and apply campaign finance laws and regulations to additional types of political communications. This caption specifically identifies a single change that the proposal would make and omits the remainder of the proposal. The proposal would make extensive changes to the Michigan Campaign Finance Act, such as regulating internet communications, prohibiting contributions by government contractors, and changing independent expenditure reporting thresholds. So I just wanted to go through a few examples that where this board has just acted. The caption that this board just adopted with respect to Proposal 1 states, a proposal to convene a constitutional convention for the purpose of drafting a general revision of the state constitution. Another example that I wanted to go through was the recent Proposal 2 from 2022, which simply read, a proposal to amend the state constitution to add provisions regarding elections. That was another sort of comprehensive revision to the Michigan election law, this being the Michigan Campaign Finance Act, but that was sort of another comprehensive revision where it was boiled down to, okay, here's the main proposal up top. The proposal in its entirety here does two things. It significantly expands the categories of political speech subject to campaign finance disclosure, and it restricts who may make campaign contributions. The two operative subjects, political communications and contributions, map directly and exhaustively onto those two categories. No substantive component of the proposal falls outside either term. Restrictions, regulations, communications, and contributions are ordinary words requiring no legal training. And in contrast to the terms of art in the bullet points below, the caption properly leaves the measure summarized. The second half of our request concerns sequencing. And our main request is that the bullet points reflect the architecture of the proposal as the signature or the proponents have drafted it. The communications bullet corresponds to sections 1, 3, 5, 6, and 9 of the Act, each which precedes new sections 30A and 30B. The contribution bullet point corresponds to new sections 30A and 30B, which the proposal inserts after section 9 and before the remaining amended sections 44, 47, 51. Presenting the communications bullet point therefore places the two provisions in the order in which they appear within the law that the voter is being asked to adopt. It's not a formality. It gives the voter a summary that tracks the actual architecture of the statute. So in conclusion, the statutory test is whether the words placed in front of the voter apprise the voter of the subject matter in plain language without creating prejudice for or against. The caption, as currently drafted, selectively focuses on just one aspect of a comprehensive proposal. And then the bulleted sequence carries over from the petition summary, inverts the statute's own architecture, and asks the voters to take the exception before the rule. We respectfully request that the board adopt the caption and the bullet point sequence set forth in our ballot proposal, our proposed ballot language. Thank you, and I'm here to answer questions.
Questions for Ms. Lowell?
As I read your proposal, it simply changes the order
Mhm.
of these.
So it changes the caption. The substantive changes
No,
to
it
the caption,
changes the caption, but
Mhm.
with regard to the substance, it changes the order.
just reorders them. Yeah.
Yeah.
You, to be nitpicky, you change bullet 3 just a hair, but I think it's better. I think your change is better.
Okay.
So bullet 3 is different than
Personally.
the original bullet 3.
Oh, yeah, it sort of non-substantive.
No, I
just
agree with you.
condenses
Yeah.
it down. Yeah.
It's better.
You like the idea of putting in the ball? I do too. I think it tells you.
Sounds kind of clunky the other way and a bit repetitive, but I just want to point it out that it was changed.
You favor the starting out with expand the campaign finance laws?
No, the third bullet point expressly
Point
apply.
expressly apply the law requiring disclosure of who paid for internet political communications.
Yeah.
Yeah, I would agree.
And I think the first,
Just takes out through words.
right, are we talking about, yes, the third bullet point?
Right.
I think there's also substantive changes to the first bullet point.
I'm sorry.
Oh,
I think there's also in this proposal, there would be substantive changes to the first bullet point as well.
Is that,
Yeah, I mean, I think it maybe is using the language from the ballot initiative or from that was from the 100-word summary on the petition.
have it regulated.
Yeah, so, well, right, so here the second bullet becomes, it's complicated a little bit because
I
of
see, yeah.
reversing the order, but currently it says, what I propose says expand laws regulating spending on political communications. And theirs would say expand campaign finance laws and restrictions that regulate spending. on
to add
political
clarification here too, we are agnostic as to either. We're agnostic as to either. I believe
Right,
we were
but-
taking the language from the 100-question summary, and that contributed to the mix-up. If we would defer to the language preferred by the director as to the substance of the bullet points.
So
But to
I'll
be
just
fair-
add-
oh.
oh, sorry, go ahead.
No, you're fine.
I was just gonna say, the reason that the second bullet here, expand laws, the reason that that's a little bit different from the 100-word summary on the petition is because that language has been added to the caption in my version. So it says apply campaign finance laws in the caption. So because it's now in the caption, I took those words out of the second bullet point, what's my second bullet point. The main reason being to get under 100 words, because we had to add other language, including should this proposal be adopted. So I think that was really the only substantive change from my proposed summary today compared to what was on the ballot. What they have done is put that language back in, which might make sense in their formulation because they have a different caption, but it is different from what I have.
I like the caption about a post-initiated law because I think it makes, we have three questions. One is about the Constitutional Convention. One, actually, we're probably going to have two proposed constitutional amendments. We may have. We have my map, which is a constitutional. Or is it? No, I'm sorry.
This-
My map is an initiative. Here, I'm mixing my
Okay.
map up because, right. So this is a proposed initiated law. We also have a proposed constitutional amendment coming up perhaps.
And
So
we
I
would
do
be
think
amenable
that it
to
makes
that.
sense to clarify whether what is being considered is the proposal for a constitutional amendment or an initiated law.
Yeah, and this is the formulation that was on the ballot the last time there was a proposed initiated law on the ballot, I believe. I don't remember how far back that was. I think that was, well, it would have been 18, but weren't those all constitutional amendments? That was a law. Okay, so that's what I would have looked at then. We can pull it up, but I guess the 2018 one was the proposed initiated law regarding marijuana, and that one was the caption started a proposed initiated law too. That's what I would have used here.
Which makes sense to me, as I said, since it differs dramatically from a proposed constitutional amendment. I know we spent a long time coming up with the language for the petition and agreed upon it. And I would stick with that language, which is what people are familiar with. So that Director Brader's proposed language with the one change suggested by Member Cummings, I think accurately summarizes the proposal and does it in a way which, as I said, people are already familiar with, so that when they're reading the ballot language, they recognize that this is something which has been brought before them before.
The one that I think, the one that I believe, Ms. Flower, that I tend to agree with you very heavily on here is that the changing the order of these, where it starts out with expanding, to me, gives people a very crystal clear idea of exactly what this is all about. And then goes into the second point of prohibiting regulated electric and gas utilities. Just from a simple funnel down, that makes a lot of sense. So I don't know.
No, except that we did it differently on the petition. So-
No, I understand that.
Right,
I
and
get
I think that that was something that we spent a great deal of time on, and recognized that that was something that was a particularly important part of the initiative. And one that
I don't think it takes
needs
away the
to
importance
be-
of the initiative. I think it simply is a more logical way to express what people are considering before they vote. Yeah, that's just my opinion.
With due respect to your point, Ms. Gurwitz, the petition language was viewed by a couple of 100,000 people, and signing the petition and reviewing that. This is the language that will be presented to potentially, the 8 million voters or whatever that we have, and who have not been exposed to this language before. So I would suggest we go for accuracy and, rather than consistency, and adopt our language, at least certainly as to the caption. And then the order makes logical sense of the bullets. And it's also follows the language of the statute, the order drafted in the statute, which people would have reviewed before also, using your point.
Again,
Yeah,
we will, yeah, we will do, but before we go down that road, before we invite Mr. Brady up too, again, I would, you know, as people who make presentations all the time, I'm just saying, if you were going to present this to people for the first time, if I were going to present this, the first thing I would tell you, I think that changing the order here simply, it helps the petition rather than hurts it. Helps the ballot initiative simply because you're telling people right up front, what are we doing here? And then you're getting down to the nitty gritty. However, having said that, I think we don't have any more questions for folks at this point. Thank you. Mr. Brady. We've made all your arguments for you. You've probably just.
See, that's still morning. It is. Good morning.
Good morning. Could you state your name and spell it for the clerk as well?
Yes, Michael Brady, Michael Brady. Good morning, Mr. Chair and members of the board. As I stated, my name is Michael Brady, and I'm here on behalf of Michiganders for Money Out of Politics. I appreciate the opportunity to speak with you today. The task at hand this morning is a narrow one, and I would say maybe, especially in light of opposing counsel's comments as well, it is the board's duty to review and approve Director Brader's ballot proposal. Ballot language statement of purpose and caption for the MOP, that's Michiganders for Money Out of Politics initiative proposal on the November general election ballot. As has already been discussed a bit, and certainly as you know, but maybe not all the folks in the audience and at home, the legal standards governing your deliberations this morning are found in the Michigan election law at MCL 168.32 sub 2 and MCL 168.485. As was touched on, but I think is important just to emphasize, the law requires a few things of you in reviewing the ballot language statement of purpose and caption. They must be true and impartial. They must not create prejudice for or against the proposed amendment or question. They must apprise the voters of the subject matter of the proposal or issue, and they must be clearly written using words that have a common everyday meaning to the general public. We appreciate the work that Director Brader has done to balance out the various requirements of Section 32 and Section 485, particularly the need to be true and impartial, clearly written, and doing so without creating prejudice for or against. We have some thoughts on each part, the statement of purpose and the caption. We think that Director Brader's ballot language statement of purpose meets the statutory standards. This makes sense, after all, as you've noted in your discussion already, because it tracks with the petition summary language. As you noted, there are some deviations as needed to make space for the question, but it, in broad strokes, tracks with the petition summary language that this board that you three, and in fact, all four of you had voted unanimously just last August, coming up anniversary at the end of this week, approved following a very deliberative and involved process lasting nearly 4 hours. Sticking with that same petition summary language you approved before, it benefits the public. It benefits the public because they are already familiar with it. We turned in 561,000 signatures, but those were just the signatures we collected within the last 6 months because there's an expiration on those. We actually had, well over, we think something in the range of 800,000 people who had come in contact and signed our petition over the course of the 10, 11 months that it was in circulation. Additionally, and I think this is important to note, there were people who looked at the language and said, no, thank you. I'm not interested in that. And so having clarity and keeping consistent language is a value for its supporters. It is also a value we believe for, I believe for its opponents. Bless you. We're not trying to pull anything over on anybody. We want people to see it and be, oh, yeah, that's the one I saw, and I'm not interested in that. It brings to mind, among other things, there was reference to our meeting a few weeks ago and the Constitutional Convention language. And there was some discussion of not changing it from how it had appeared 16 years ago, because maybe somebody remembered that. I voted at that election. I don't remember the Constitutional Convention language, but there are a lot of folks here and watching at home and otherwise who have seen this. It's been circulated, widely circulated. It's been in the press because of your meetings and otherwise. So, for those reasons, we think the statement of purpose as drafted by Director Brader, and certainly the sequencing and the order is a part of that, how voters engage with it. I think one other thing to keep in mind is, with respect to the sequencing and order, the proposed order by my opponents is how Director Brader had initially submitted it to this board ahead of the August 22nd, 2025 meeting. And part of the conversation in those 4 hours was to affirmatively, you all from your deliberation, to affirmatively change the ordering in order to make it more clear by keeping certain parts of, I went back and watched it and tracked my memory, to have certain parts that were similar to each other. So moving the prohibitions on contributions to one part, and then having the other parts that are more the campaign finance regulatory aspects to have them next to each other. That was a compromise effort. It was something that involved input from me, from opposing counsel, from the public, and an active debate. So in that regard, of course, the board can do what it wants. As you know, you're allowed to change it this time. But the question I would ask is, who does that benefit? How, and more to the point, how does it benefit the public when you had the deliberative process, you invested the time, you heard from everybody, a year ago, and you made a decision then. And so, if it's not broke, why are we fixing it? With respect to the ballot caption language, there are a couple of tweaks that I raise for your consideration. Small things, but I'll pass them out. The first suggested edit would be to replace the opening phrase, a proposed initiated law, with a proposal to amend state law. The motivation for this comes from Section 485 and its mandate that the ballot language be clearly written using words that have a common everyday meaning to the general public. I've received feedback from the general public that the general public may not have a common everyday understanding of proposed initiated law. They do know what a proposal to amend state law means. And in looking at the caption and purpose structure for the last 3 statewide questions in 2022, the caption read, a proposal to amend the state constitution to, it would go on from there. And the purpose said, this proposed constitutional amendment would. And so while those were constitutional amendments and not amendments to state law, my client believes that that is clear language for the general public. Relatedly, as you can see, my second suggested edit, which is tied to the first, would be to replace the phrase, the proposal would, with this proposed statutory initiative would. I think both of these, they're not exactly the same, but they seem to be in line with the proposed ballot language from opposing counsel, perhaps for the same reasons or not. My third suggested edit is to delete the word certain before the word regulated, and then to add the words electric and gas after the word regulated and before the word utilities, so that it would read, to prohibit campaign contributions from regulated electric and gas utilities. With the thought that this greatly clarifies what this is about. It is language that is true and impartial, as this board has already found it previously to be approved, to be so, and has approved that under the same standard which applies for the proposal as for the caption. So with that, I cede my time back and ask if there are any questions.
I have a question for you. So if in your proposed change of a headline of caption, you specifically call out regulated electric and gas utilities. But this goes beyond that, right? This also involved any company at all that's dealing with the state of Michigan for more than $250,000.
Does, yeah.
Well, I would say that by saying that that's just gas and electric utilities, isn't that a bit misleading?
Oh, well, so first I hear you on that point, and it's not, it also, those that you've just identified are also not certain regulated utilities. So we were reacting to the language from Director Brader, given his statutory responsibility to draft the language, and in turn your obligation to review his language. And so what you point to is a distinct class of folks who would be affected by this, that are identified in the proposal language, in the statement of purpose language, that are not currently spelled out within the caption. And that's true for Director Brader's starting point language as well as ours. I'm not necessarily opposed to that. I hear you on those points.
No, but I'm saying, I mean, again, that looks like a little bait and switch to me. That's wrong term for me to use, but I don't know an easier one. So there's a company in our community that sells restroom supplies to the state of Michigan. A whole lot more than $250,000. They are just as affected by this legislation that you're proposing as a gas or utility. Is that correct?
If they've got that contract directly with the state, then yes, it would affect them. You make a good point. I can't speak to why it didn't make it into the other language, but my client's proud of what's putting forward. We're not opposed to making that change.
Seems like it's substantive though. I mean, and if you look at the economic news, I mean, $250,000 today is about the price of a week's groceries, right? It's a little more than it used to be.
Thanks to President Trump.
I know, I was giving you an open. The point being is that it just seems like that if because of that, this is a whole lot more than gas utilities, which could materially affect what a voter is voting on.
Mhm. Yeah.
Um,
Again, I would say, I hear you. You make a very good point. I can't speak to why it didn't make it into the
Right.
initial language, but I'm not opposed to adding that language either. Perhaps it would say a proposal to amend state law to prohibit campaign contributions from regulated electric and gas utilities and contractors with over $250,000 annually in government contracts. Because I believe, and it's worth confirming, that the caption does not have a word limit. There's kind of a practical space limit.
correct.
But
Does that
you
work?
make a good, a very important point, and one that we do not object to.
Does that work for you?
It does.
Mr. Gordon, join us.
What I've heard is a lengthy argument about how consistency is important. We can't change anything. We can't adopt the language, the clarifying language that we proposed, because it wouldn't be consistent with language that was on the petition and that this board has already approved. But let me tell you about my changes. Apparently, that argument doesn't apply to something proposed by the petitioners as it applies to us. The thumb's already on the scale, we think. The language, and we're not accusing anybody of doing anything inappropriate, but this language, we think, as adopted or as proposed by the staff, is biased toward my clients. This is an all-encompassing proposal. It isn't addressed only to electric and gas utilities. You've pointed out very well, Mr. Chair, that this applies to companies doing over $250,000 of work with the state of Michigan. There are a lot of companies. It's not just electric and gas utilities. That is deliberately designed to prejudice people and try to encourage them to support this. And I point out in the bullet point, it already says prohibit regulated gas and electric utilities in the language by the director. So this is overkill. Putting it in the caption is not necessary, and it is misleading and biased toward my client. And it totally contradicts the other arguments that everybody's been made here, is that, well, we can't adopt any of your changes because we've got to be consistent. We object to any changes proposed by the petitioners, using his own language and using the language of the board. And we would propose that our language be adopted because we think it's non-bias. It is a more appropriate and clarifying statement of the proposals. That's all. Thank you.
Ray, do you want to comment on that?
I just want to respond to at least one of the points raised, that I argued that no changes be made and then proposed changes. My argument is that that I concede you're allowed to make changes to the statement of purpose. But the question for me would be, why are you making the change? You don't have to answer that for me, but I ask you to, each of you, to encourage you to ask the question for yourself. To what, who does that benefit? Does it benefit the public? For the reasons stated, I do not believe that a change to the statement of purpose does advance the interest of this board or of the public at large. And the statement of purpose language, my opposing counsel, suggests a change to the ordering, but otherwise seem to agree on not really changing the substance of the text. And so in that regard, there seems to be, some consensus there that tracks with Director Brader's as well. So with respect to the statement of purpose, there's a general, my observation is that there's a general consensus that the text itself should not be changed. There's a question that remains on the table for the statement of purpose as to whether the order should be changed. That's where we disagree. However, the changes that I proposed are changes to the caption. The caption is a new thing. It's never existed before. And so in that regard, these are not mutually exclusive for me to both argue, keep what has existed more or less the same. But for that thing that's brand new today, if anything, the changes I'm proposing are directly from the statement of purpose. So it's not, he doesn't have to like it. Other people don't have to agree with me. But I'm not being, I don't believe, intellectually inconsistent by acknowledging that which has existed can and should remain the same, but which is brand new today as a discussion topic, the caption, that the greater value is in tracking with what has existed in the past. That might not be enough to win the day. I understand that, but I just don't think it's inconsistent. That's the only point I wanted to make.
Let me speak for a second. I know, Mr. Gordon, I wanted to ask you, based on your comments, that we said we want to be consistent, but now we're saying we're going to change stuff. So
I'm sorry, you're not saying you're going to change stuff. I'm arguing against.
I get it, but we were welcoming to some of his changes. So I want to clarify that what we are discussing right now is new today. Is that correct? It's been a year, so I need to remember. Sorry, the caption we did not draft.
Yes, the
that
caption is new.
Okay.
It was my attempt to make the caption consistent with the substance of the,
Okay.
but it is new language.
That's new.
That
And I think we do all agree that we're pretty close. The substance, I think everyone's almost in agreement. The caption is new, so, and then to Chair Housecamp's comments, The regulated utilities is in there. That was not Mr. Brady's suggestion.
Regulated
Utilities is
electric-
in there. I'm arguing that if this caption to me should reflect, if the caption is gonna reflect regulated utilities, it should also reflect the fact that
Right.
you don't have to be a regulated utility. You just have to have 250,000 in government. I think we have to reflect that.
I agree. I think we need to add that.
So regulated utilities and government contractors. Some government contractors.
I'm not even sure I would add the word, it's the 250,000, I guess, that's the threshold, right?
And I agree about the 250.
The
Right.
reason
Right.
we broadened the language in our proposed caption is that once you start identifying individual companies that may or may not be regulated by this, you start going down a rabbit hole and get
Yeah.
into all kinds of detail that you don't need to do. And that's why and we think that that is bias. It identifies a small part of this statute. And it doesn't recognize, much of the other changes in the statute. And that's why we broadened our language to state a proposal to impose new government restrictions and regulations on political communications and contributions. That's what this proposed, this initiated law does. Now, I agree with Ms. Gerwitz's comments that maybe it would be more clarifying, particularly in light that there's a constitutional amendment on the ballot, that maybe it should state in an initiated law to impose new government regulations and restrictions and regulations, as we've stated that. But once you start saying that, well, this prohibits political contributions by certain regulated utilities. Oh, it also prohibits certain political contributions by certain government contracts. Oh, it also changes the contribution or the definition of communications. Oh yeah, it also changes some of the reporting requirements. So, that rabbit hole that you're starting to go down, you can't get all that detail in the caption. And the way the caption's phrased, it singles out a couple of things that we think create bias in favor of the proponents. Why not state in generality what it does? And that's what our proposed caption says.
Mr. Brady, is our, like Blue Cross Blue Shield, Priority Health, Corewell, are the health systems in Michigan, those are all regulated too, aren't they?
That is my understanding. I think also hairdressers are like regulated. I mean, there are a lot of different, in all seriousness, there are a lot of driver's educations regulated by the state. I mean, my rough understanding of civics here would be that the government creates laws to do things, and when the government acts, it does so by way of law, and I mean, certainly the legislature. And so the extent of regulation exists in far and wide throughout the state. And that, among other things, is where I think the, some of the broad language that, my opposing counsel has suggested, that's where I think it is a step too far, so much that it makes it no longer, meet the standard of being true and impartial, and certainly not clear. This does not have anything to do with hairdressers or drivers ed instructors or the like, unless they somehow also connect the gas and a regulated gas and electric utility. That was an amendment that came up last August. Mr. Liedl, then opposing counsel with Dykema for PMFS, had asked for that, and we conceded that as part of that larger 4-hour negotiation. So I've returned to in the comments that I think Director Brader's language meets the standards. It builds on the language and is consistent with what you all have already actually adopted, with, I would say, the amendment that you've proposed, which I think is the right amendment. We're not trying to, hide the ball for any of those contractors. I think to include government contractors is valuable there, and I think it should specify the 250,000 just as you do.
We aren't talking about regulated industries. We're talking about regulations on political contributions. And so maybe Mr. Brady's hairdresser makes some big contracts with the state or not. It doesn't matter whether they're regulated. This is a regulation on political contributions. It doesn't regulate industries or industries that are licensed or regulated by the state of Michigan. So that's a distinction that's totally
Out of
different.
sheer curiosity, you know, as lawyers, you folks are regulated by the state every year. Is that correct?
Or licensed.
I don't know. I kind of like it now.
We're
Um,
we're regulated.
I'm growing fonder here.
But we're regulated by
Um,
the State Bar of Michigan.
I have,
Yes.
As as Member Cummings pointed out, there are some things that we are in agreement. So how about if we clarify that? I think both Mr. Gordon and Mr. Brady would say that under the caption, it would say this proposed statutory initiative would, right? That's language that each of them have. And I think we agreed that the change suggested by Ms. Flowers on the bullet expressly apply the law requiring disclosure of who paid for internet political communications. So we would delete the 3 words political communications too. It makes more sense this way, I think.
I think so, but
Um,
Brady, are you okay with that?
Are we starting from Director Braders?
Looking.
Let's do that last bullet point first. It says that you're changing. Let's read that last
That's
bullet
okay.
point out loud.
Oh, the very last bullet
Last.
point. Yes,
Okay.
yeah, I'm okay with either version. I think they both,
Okay, so those were agreed on. So the 2 things we are still discussing are the order of the first 2 bullet points and the caption. I find myself in agreement here with Mr. Gordon because it is speech that is regulated, the speech of, or political contributions of not just electric and gas utilities, but of contractors.
Correct.
So it wouldn't make sense to say just to add to the regulated utilities and government contractors because the applicability is much greater than that. So, yeah, the imposition of new regulations.
Excuse me, Ms. Gerwitz, are you speaking to a bullet or to the caption?
I'm sorry, what? To the caption.
Caption, okay.
oh, okay.
Can I interject just a couple of
Yeah.
things? So first of all, so there is one of the distinctions. So first of all, I agree that the caption, I agree with the idea of the caption including reference to the contractors. But there is a distinction in that the proposal changes the way political communications are regulated for everybody. But it only prohibits contributions from utilities and certain contractors, right? So that's why those are spelled out differently. So if we were going to change that, I would suggest something like from regulated utilities and certain government contractors or something like that there. That's one thing. The second thing I would just say is I don't actually agree with the changing the proposal would to the proposed statutory initiative would. Just one thing that adds words and we're right at 100.
Oh, that counts.
Yeah,
Okay.
and another thing is, I mean, I don't know that that's necessarily clear. I respect what's been shared, but I think proposal is pretty clear. Especially if we're keeping proposed initiated law in the caption, which is what was there for the 2018 proposed initiated law, then I think proposal is perfectly fine. The other thing I'll just say as we're discussing this is, the proposed change to the bullet of expressly apply the law requiring disclosure of who paid for political communications to internet political communications, changing that to expressly apply the law requiring disclosure of who paid for internet political communications. Respectfully, I don't know what that means. I mean, because currently the law requires you to disclose who paid for political communications. And arguably, you know, it's unclear how that applies to internet communications, internet political communications. So what this proposal would do is say, it definitely applies to internet political communications. But if you're just if you don't know that and you're just reading this bullet point, which just says expressly apply the law requiring disclosure of who paid for internet political communications. I think what they mean there is expressly apply the law, the Campaign Finance Act, which requires disclosure of political communications so that it applies to internet communications. But I don't think that bullet makes that clear. So I would disagree with that change, obviously open to other types of changes, but just wanted to get that all out there as we're discussing these things.
Say that again.
Yeah.
That's language is
Yeah.
really.
So currently, the Campaign Finance Act requires you to disclose who paid for political communications, generally. There's nothing in there because it's an old act, it hasn't been amended very much. There's nothing in there in that section about internet political communications. So there's arguments sometimes about whether the current structure of the Campaign Finance Act, like how it applies to something that's like on social media or on a, you know, on an internet ad or something. And so this proposed initiated law would add a section of the Campaign Finance Act that clearly states that it applies to internet communications. So the way I had structured it, which is what was on the petition as well, was expressly apply the law requiring disclosure of who paid for political communications, which we currently have, to internet political communications, so that it applies to internet political communications. But the way they have it written, I think they mean the same thing. I just don't think it says, I don't think it says that clearly. It just says expressly apply the law. It sort of makes it seem like there's already a law requiring disclosure of who paid for internet political communications, and it's saying that expressly applies, which maybe, I mean,
No, I agree.
I
with
think it's
what-
just a little bit unclear the way they've changed it.
I would agree with your wording on that, Director.
Could we expressly require the
It
disclosure?
says, they say two different things.
And we're fine deferring to
I'm sorry.
the director. We're fine deferring to the director on that.
You're okay with
We
the
don't need
director's
to,
wording?
yeah, we don't need to spend time on that part if that's where the board
Wanna
is
die
gonna
on a
land.
hill, do you? I got it. Okay.
As are we.
Um,
So, and we recognize that adding proposed statutory initiative instead of proposal adds 2 words, which we don't want to do, right? Maybe, depends on how many words we have, right? So, but, and there was one other change that you were suggesting, Ms. Flowers, that, let me clarify what that was.
Yes, using the language in the director's bullet points, we would invert bullet point 1 and 2.
Right, but there
Yep.
was something in the text.
It was
Director Brady referred to.
the expand laws or expand campaign finance laws. That's the difference.
And it's just a matter of having it either in the caption.
That's right.
Or in the text of the proposal. We agree that
Yeah.
the law being amended needs to be referenced in some fashion.
And again, the reason that I moved it into the caption from the text was because we needed to add additional words elsewhere in the 100 words, so we had to pull some things out. So that's why it says expand laws instead of expand campaign finance laws. And I moved the campaign finance laws reference to the caption, which does not, the 100-word summary, 100-word limit doesn't apply to that. But again, as discussed, we do have a practical limit because we can't have a caption going on and on and on.
So,
We would prefer it in the
Brady, you
caption.
suggested resolving the dispute that we had about the caption to say a proposed initiated law to prohibit campaign contributions from certain regulated utilities and certain government contractors. I think that the word certain is applies to both, certain regulated utilities and government contractors. Or would,
I think that has to be in there, though. I really believe that.
yeah, I think that should be in there as well.
So I generally agree with putting government contractors in the caption. I think that's a good change. I think that where the certain goes, we could probably talk about that. I don't know if I think I'd be okay with either to put it before regulated utilities. But it might be more precise to put the certain before government contractors and take it out from before regulated utilities.
Yours would read campaign contributions from regulated utilities and certain government contractors.
Yeah, I think that's what I would propose at this moment.
I think that fits.
If I may, the one concern I have about removing it from or just leaving regulated utilities. If you don't include electric and gas, I would just note, water is an obvious utility that is, of course, regulated. All utilities are. And so that's, just like another dynamic that I think does, beg questions there.
I agree with that.
So that's where, I mean, while I
think the
don't,
certain should go more to the front, yeah.
while I don't love the including certain twice, that at least would beg a question of terms of which one they can then look down. But removing it, I think, actually makes it inaccurate, and that would be a concern.
You're saying there are some regulated utilities that won't be covered?
Like the Great Lakes Water
Water.
Authority, for example.
Water?
Water.
Yeah.
That it's only certain
Yeah.
gas and electric.
In the measure, it defines it as those regulated by the MPSC.
You agree with that?
I think that including regulated utilities and government contractors, I would rather rely on the text of the bullet points below. I think that when you get into regulated utilities, contractors, when you look at the text of the measure, it's really comprehensive and goes into family members and all sorts of things beyond just the entities themselves. I think that our request, consistent with the caption we put forward, keeps it broad, says you're making changes to who's regulated by the Michigan Campaign Finance Act and how that's disclosed. But I think that we have a solid set of bullet points that everyone has agreed to, and we think it's less biased to just rely on those bullet points.
And I don't, glad we all agree on the bullet points. I would just say pulling language from, if the bullet points are not biased and they can proceed, then pulling language from those, I think it logically tracks, also would not be biased. So.
Oh, stay on the caption for a second. The real conversation here is focused on whether we need to mention certain one time or two and where we're planning to put the word certain. Is that correct?
Yes, after further consideration and comments from council, I'm back to thinking certain should be going in front. If we keep it similar to what I proposed, I think it makes the most sense to say certain regulated utilities and government contractors, because it's certain utilities and it's certain contractors. It's not all utilities or all contractors.
Would you read your new head? Would you read a revised caption that
Yeah.
you're suggesting?
So I would say, a proposed initiated law to prohibit campaign contributions from certain regulated utilities and government contractors and apply campaign finance laws and regulations to additional types of political communications. Now with that, there was also sort of an idea of just having a much more general caption that doesn't go into this much detail. I think that's fine in principle. Like, we have done that. We've done it both ways. The board has done it both ways. For example, even on the topic of elections, if you look at the 2018 3 proposal, which was like automatic registration, et cetera. That one said, this is 2018 3. This is one on was on the ballot. It said a proposal to authorize automatic and election day voter registration, no reason absentee voting, and straight ticket voting, and add current legal requirements for military and overseas voting and post-election audits to the Michigan Constitution. So that's how the caption summarized that one. I wasn't around for that one, but seems fine to me. But then the one from 2022, I remember I had drafted that one to sort of try to do the same thing with the ballot changes there that did a bunch of things. And after a lot of discussion, the board decided, let's not try to list all those there. Let's just say a proposal to amend the state constitution to add provisions regarding elections. And then there's more detail in the content. So I think either one is fine. The only thing I would say here is that we do need, if we go for a sort of more streamlined caption, I do think we need to have something in there that indicates that this is talking about campaign finance laws, because I did take campaign finance laws out of the bullet points because they were in the caption. So I think with all that, I think what I just said in terms of making the certain utilities and government contractors would work for me, but I'm also open to a broader discussion about the caption. We just might need to make some other corresponding changes if we went in that direction.
Question before you turn your mic off. Question about if you were to take a stab at the shorter caption, you were to take a stab at a proposal to impose new government restrictions and regulations on political communications and contributions, if you were to take a stab at a shorter one, what would that, can you give us a recast?
I think it would be, I mean, just first, without thinking about it that much, it would be something just like a proposal to amend a proposal to amend the Michigan Campaign Finance Act to prohibit, prohibit and regulate additional communications or something like that. It's more general. Probably needs some tweaking, but it would be just sort of a general reference to, we're changing the Campaign Finance Act. We're prohibiting and regulating some additional things that are not currently covered.
It's essentially what you're saying in your caption.
Yeah,
Right.
yeah.
That trying to, suggesting a change from the more limited one essentially gets you back to the one that you already had.
Yeah, I mean, we could get it shorter, I'm sure. I think it would be a little bit challenging to, I mean, unless you just said a proposal to amend the Campaign Finance Act. I think it would be hard to add more detail about what you're doing without then getting it looking more like what we have there.
And we agree, because what he's doing, what we're doing here is we're focusing on the limitation in contributions. We're focusing now on that in the caption. We're focusing on that on the bullets. And that's not all that this does. It's a lot more general. And I think that focusing on that is the sexy part of the statute, and that's going to attract people and their attention. And I think that creates bias in favor of the proposal. So I would go back but instead of being covered in the caption, even though the bullet points again highlight that issue, I think at least the caption should state that it does a lot more than limits contributions by contractors and regulated utilities. It is a proposal to impose new government restrictions and regulations on political communications and contributions. If you want to say it is a proposal to amend the Campaign Finance Act or the Michigan Campaign Finance Act to impose new government restrictions and regulations on political contributions and communications, that's fine, and that clarifies that is something that the director suggested, and we'd agree with that. But to focus on utilities and contractors and to forget about the rest of the statute creates bias in favor of the proponents and is not clear. It does not cover what the statute does. It focuses on a small part and ignores the rest. And when you do that, you're putting your thumb on the scale, and we don't think that's appropriate, especially when those subject matters are covered in the bullets. So why don't we state in general, what is this? And what it is I won't repeat it. It is a proposal to amend the Campaign Finance Act as we suggested in that caption. And that's broad. It doesn't create bias for anybody or against anybody. And it covers the entire statute. The bullet points get into the nits and get into the contributions. And the points that the proponents and the director want to cover are covered there. You don't have to repeat it in the caption.
And I would direct you for Director Brader's proposal. The last two lines do exactly what opposing counsel speaks to. It's not just about prohibiting contributions. That's not what Director Brader wrote. What he wrote was prohibiting contributions. We've already discussed, and I've conceded that I think there's real value in adding in $250,000 government contractor. And then it goes on to say, and apply what? Apply campaign finance laws and regulations. These are ones that already exist, disclosure obligations. We're applying things that are already, the prohibition on contribution is new for those entities. By contrast, there is already an obligation, there's already regulation that exists for political speech, but it is extending that to different forums and making perfectly clear that what is already an obligation if you're buying yard signs will now be an obligation if you are buying Facebook ads. And that is exactly what Director Brader writes in lines 3 and 4 of his caption that you all have in front of you. And so in that regard, I think it does address exactly what opposing counsel was speaking to. But you've heard both of us go around a few times on this. So, I appreciate the opportunity to speak when he speaks. But ultimately, I'm available for questions if that's helpful.
I think Director Brader's proposal, just adding government contractors, really clarifies what this does. So it's prohibitions and application beyond existing laws. So
And it's actually state government contractors, correct? It's not government contractors. Just to
Plus the
throw
local.
another,
Well, yeah,
It's not just state,
but, well, it could be,
local.
I think it could include if you had a municipal contract too. So if you had like a contract with like the city of Detroit or something, I think you would still be covered. Is that right?
it would be covered.
Maybe not. We should verify that. But I also don't know that we need to. I mean, we could say state. I don't know that we need to, but
certain modifies both regulated utilities and government contractors. So
yeah, I think it does include local. So yeah, so if you had like a big contract with Detroit or Grand Rapids or something, you would still be covered by this.
Federal contracts are not covered, correct?
Correct.
I don't think so.
don't
I mean, I don't think
They're
we'd
not-
be regulating.
No.
I don't see how
They're
we'd be
not covered.
regulating
No.
contractors with the federal government, but we also don't say state contractors in the summary either. So I would just leave that out personally.
Mr. Brady, just a question for you as we're working
Yes,
through the caption. And you referenced this a few minutes ago.
Mhm.
In terms of the ordering, did I hear you say you're kind of fairly agnostic about what the ordering is of the bullets? Or did I not hear that?
I don't know that you heard that from
Sometimes
me.
I hear what I want to hear.
Sure. Our preference, my client's preference, is to keep the ordering the same as it had been approved by you all when you made the affirmative shift after a few hours of deliberation and changed it to the ordering that exists in
Back
the
and
petition.
forth,
Yeah.
yeah. Okay.
I admire Mr. Brady for going back and watching that very long discussion we had about the caption, or not about the language on the petition. I don't know if we want to revisit that more, but it looks like we're going to do it all over again and have another very long meeting.
No, I think we can get this resolved quickly.
I think we can too.
Mhm.
Right. I think that, that the limited change that we have agreed to, in the caption and government contractors, if we did that, I think we'd be good.
Let's nail down that caption then. And let's do that. So let's get a caption and read it from the top and have agreement on the caption, and then we can figure out what to do with the points.
Okay, so you're going to print it out for you? So, or do you want me to just read it out?
Or just read it out and
Okay.
have a clear. read
So,
of it.
yeah, so the new proposal would be keeping the substance below the same. It would say a proposed initiated law to prohibit campaign contributions from certain regulated utilities and government contractors and apply campaign finance laws and regulations to additional types of political communications.
Comments?
No, I think that sounds good. Look at, that's what I've written right here.
You can almost read your writing there. You have it right there.
Right. Because, yeah,
Okay. Well, let's talk about bullet points. We've already talked about the third bullet point.
and we decided not to
leave
change it,
I did,
to keep it the way it was. right?
Yes.
Yeah,
Yeah, so we're really
Yeah.
down to 2 bullet points here.
right.
Director Brader, do we have to change wording anyway on those bullet points because we've added wording to the caption?
No,
Okay. I think you said that. I just wanted to hear it one more time.
no problem.
Comments on the,
You know, as I said initially, I don't see any reason to change it from what we agreed to with regard to the petition. These are, they're both important bullet points. But the order that we agreed to a year ago, I think makes sense. It highlights the prohibition on contributions and then goes on to expand laws on other communications. And, you know, each of those is a significant part of the proposal. The prohibition on contributions is one that I think is particularly significant and deserves to be upfront. I said the prohibition on these contributions.
So leave it as.
I would leave that as the first bullet
Okay.
point.
I'm trying to line up a couple words here.
Okay.
Expand laws regulating spending on political communications versus the expand campaign finance laws and restrictions. Brady, you have not materially changed the second bullet point between what director, you, a little bit you have. Expand laws regulating.
I don't believe I've made any changes
You
to
haven't
the,
changed anything there. Okay.
to the director's bullet points.
I like the call out of campaign finance laws, but I don't think we can change that. We don't have enough words. I'm sorry. Correct. Yeah, yeah. Yeah, I've shared my feelings with you. I mean, from a marketing standpoint, I would get into I would reverse the points, but I understand your concern. I understand the board's concern. I don't-
You're agreeing with Member Cummings said.
Let's not get excited about this yet. Let's not. Be careful here. Yeah, you know, again,
Did you hear, Mr. Brady say, I do not recall that, that was very, important, that when you looked back at the meeting from last year, it was presented to us the other way.
Yeah.
And we switched it.
we switched it.
And now we're talking about switching it back.
Well,
I mean, it's an interesting point.
again, Mr. Brady, if
Yeah.
I were, if, you know, we always call them elevator speeches.
I believe
right?
you, yeah.
If I were going to walk in and pitch you with an idea that I wanted you to sign on board with,
Mhm.
just from the ordering standpoint, the way that Ms. Flower and her team have the ordering switched. If I were going to sell this as a concept, that would be exactly the ordering I would use, rather than go down the rabbit hole of exactly what,
Sure.
you know, again, I'm asking you how you look at it. I would not typically be the part of this board that would support this
Mhm.
petition, but I'm telling you that from a marketing standpoint, by
Right.
switching these bullets around, you've made a more compelling, you've made it easier for a voter to understand exactly what you're doing.
Well, we're going on an anniversary. I think it's this Saturday, is the 22nd.
You're okay
Anniversary.
with it either way.
Um, No, I would say that the reason, I'm going on anniversary, so I can understand, perhaps that,
See,
not remembering all, but the, the discussion that occurred,
Remember all that.
yeah, was,
I was here.
right, of course.
I was here and I don't remember.
Yeah.
So,
And so,
just being honest.
but the discussion that occurred was, discussion of like regulating political communications, some kind of existing campaign finance laws, updating, expanding, who they apply to, with having the regulated, the prohibited contributions being in the middle. And so the feedback that I had offered and the reactions from the board, and Mr. Cordes was part of that, and the like, was to shift them, to put them kind of the new contribution right up front. Contribution restriction is new, versus the others, which broad strokes already exist. There's a longstanding regulatory framework that applies to government regulation. It applies to the Campaign Finance Act, and as it applies to campaign speech, but takes it from yard signs to apply it to internet ads, for example. And so by putting those two together, that was the conversation, that was the back and forth.
I do remember that. I don't have it's gonna be 6 of one, half of the other. I like the fact that we've changed the caption. I think the
Yes.
caption would be
I agree.
a better way to go.
So I would move that we accept Director Brader's draft with the change in the caption, which we have noted. The change being a proposed initiated law to prohibit, excuse me, campaign contributions from certain regulated utilities and government contractors, and apply campaign finance laws and regulations to additional types of political communications.
Second.
Been moved and seconded. All in favor?
Aye.
Okay. Thank you, everybody. Thank you all, by the way. You know what? Those were all good comments, all good stuff.
Mhm. Mhm.
We have we're gonna move on to public comment.
Should we take a
I'm
break?
Assuming a lot of them are gonna get dropped off.
Right, that's true.
We're gonna move on to those.
Yeah,
Yeah.
yeah, that's
But I'm gonna, do you mind if I mix this up for just a second? Can we take like a 10-minute break before we do that?
Sure.
Yes, that would be good. Okay.
Yeah. Thank you.
Thank you. Thank you. Thanks so much.
you.
Okay, let's go back to order here for just a minute. We have a whole bunch of public comments. We have folks here, we have folks in the overflow room, and we'll listen to your public comments. But before we do that, we're gonna take a much needed 10-minute break. We'll be back here at 25 minutes to 1.
I would
Thank you for your patience. We're back here again. We have a bunch of public comments. My understanding is that everybody is in this room. Okay. And I'm just gonna go through them. So if you're here, you get 1 minute. And I'm just gonna, let me get it all lined up here a minute, but we're, all right. We'll do 1 minute, and no questions from the board. First one up is, yes. William Asher? No William Asher. Terry Wilkerson? Michael Lenz? Betsy Moskowitz? Are you Betsy Moskowitz? Come right up here, ma'am. If you would have a seat at the base of that microphone is a small button, and when you hit it, it's going to make the top of the mic look red. Then you'll know it's on. Base of the microphone. No, I'm sorry, base on the table. Little black button there. Is it a red button? Ah, no. Oh, there you go. You got it.
Oh, sorry.
No, that's okay. But if
Right,
you would,
right.
before you address for your minute, would you state your name and spell it for the clerk, please?
Betsy Ann Moskowitz, Betsyann, Moskowitz, as in zebra. I'm from Augusta County, Remus, Michigan. And I am grateful to have most of this language preserved, hopefully, because this ballot initiative had specific language that was hammered out a year ago by this board. And there's been about 800,000 signatures of registered voters who approve this language and this intent. And it is important because you can't compare the disparity of big muscle money monopolies versus how much the voices are heard of the average voter. Thank you.
Matt Love. Sarah Brabs. Ms. Brabs, if you would do the same thing, name and spell it for the clerk, please. And nope, you had it on there. There you go. Now it's on.
Sarah Brabs, SarahBrabbs. I wanted to thank you because as I've gone around Michigan talking with people and this petition has come up, along with the times that I've circulated the petition myself, people commented from all over the political spectrum, all over the state. When they read it, it was explicitly clear. They also usually asked really good questions, and people that didn't want to sign it didn't sign it. And so I think it's going to be really helpful for all types of voters to do that. And I don't know if you ever saw that New York Times article, the most bipartisan issue since beer, about data centers. I know it's not the same thing, but the sort of clarity and of course this makes sense, it was like that, so I appreciate this. Thank you.
Thank you, ma'am. Sonia Shoup. Microphone's already on if you name and spell.
Yeah, follow directions. Got it. Okay. My name is Sonia Shoup, SonyAShoup. So Mr. Gordon from Protect Michigan Free Speech repeatedly stated that there's a thumb on the scale in this fight, and I would agree that thumb is theirs. So Protect Michigan Free Speech has received tens of thousands of dollars into each from Consumers Energy, from DTE and Blue Cross Blue Shield, as well as a number of other groups, both directly and through dark money groups. That is major corporations using their massive wealth to try to outweigh the voices of hundreds of thousands of Michiganders, hundreds of whom I've talked to personally. And that's exactly what this petition is about. So I thank you for keeping the language the same. To truly protect Michigan free speech, we must protect the voices of individual Michiganders against the deep pockets of special interest groups like theirs. Thank you very much.
Thank you. Jennifer? Jennifer? And if you would, again, yeah, mic is already on, so if you just state your name and spell it for the clerk.
My name is Jennifer Schlitt, SCHLICHT. Yeah, I don't have anything prepared because this was a very nice surprise. Do want to thank the board for your decision today. I think it's fair, honest, and I think that the voters will appreciate it in November. And honestly, I've been collecting signatures on this since Labor Day last year as we built up momentum and created a really true citizen-led movement. So partisan in nature, I've had, sorry, whew, I'm really ran out of here. I apologize. Yeah, so, I've talked to voters all across the state and folks collecting signatures as well, from Republicans to Democrats to Libertarians to the furthest edge of hippies. And that was all at a single anti-data center meeting. We're all, I really appreciate the board's professionalism in all this. And thank you so much. And that's all I really got. Take care.
Thank you. John, John's gone. Oh, you're all set? Beautiful. Your pen went bad on the name here, so I was sweating the fact that you would ask which Sean, then we'd be in trouble. Christy McGilvery. I'm sorry? It's gone? Okay. Duncan Donahue. Need your name and spell it for the clerk, please.
My name is Duncan Donahue, Duncan, Donahue. I'll keep it brief. I just want to say thank you to the board. I've been here for every meeting at which there's an MMOP matter to be discussed. I think the board did a great job with the language last time, circulated the petition to thousands and thousands of people. People were, they found it easy to understand for a very complex subject. And they knew their stance pretty quickly for or against in terms of the ballot or the petition language. So thank you for, I'm sure it's sometimes maybe a thankless job. And there's probably a lot of lawyers from different sides yelling at you a lot. So I just wanted to say thank you.
Thank you for thanking us.
You come back anytime you want, sure. Bonnie. Bonnie, she's not here? Okay. Wesley Wilson. Nicholas Pigeon.
Hi, Nicholas Pigeon, Nicholas Pigeon. All right. Well, good afternoon, board. My name is Nick Pigeon. I formerly was an executive director of a nonpartisan nonprofit that examined money in politics in Michigan and explained current and proposed campaign finance law to the general public. My comments originally were written in the spirit of public comment to persuade you, but we're talking after the decision was made, which is fine. So I did want to commend the board. Your responsibility here was to not have a caption that persuaded voters one way or the other. It should give them an accurate and impartial description so they can make the decision for themselves. In my opinion, Director Brader's language did just that, and I think that he made minimal changes that did make sense. I thought that the caption proposed by My Free Speech was so broad as to try to persuade and to confuse voters from the petition that they might have signed earlier in the year. So I appreciate you not adopting that. Whatever one thinks of the underlying policy, it's clear that Michiganders care deeply about the impact money has on politics, and they deserve to have a fair vote in November. And I just think that we're one step closer to that with your vote. So thank you.
Thank you, sir. Robert Nelson. Lisa Spitz. Ethan Weichert. That represents the last of the public comments. Outstanding. Moving along, item number 7, is there any other business to present to the board? That being the case, meeting is adjourned. Have a great day. Drive safe on the way home.